In episode 20 of the Supreme Court Opinions Read podcast, I'll be reading the Supreme Court's opinion in Barrett v. United States. The case was decided January 14th, 2026. And as always, we'll start with the syllabus. This case concerns the relationship between two provisions of 18 U.S.C. Section 924, subsection C1A1, which criminalizes using, carrying, or possessing a firearm in connection with a federal crime of violence or drug trafficking crime, and subsection J, which prescribes different penalties, including, in certain circumstances, capital punishment, when a violation of subsection C causes death. The question presented is whether a single act that violates both provisions may yield two convictions, one under each provision, or only one. The Second Circuit held that one such act may yield two convictions. The Second Circuit acknowledged that subsection C1 and subsection J qualify as the same offense under the test in Blockburger v. United States, but it believed that, as construed in Laura v. United States, the two provisions are separate offenses for which Congress has clearly authorized cumulative punishments. Because the Second Circuit's decision deepened a split among the courts of appeals, this court granted certiorari. Held, Congress did not clearly authorize convictions under both sections 924C1A1 and J for a single act that violates both provisions. One act that violates both provisions therefore may spawn only one conviction. The part of the Second Circuit's judgment that held otherwise is reversed. Part A. When enacted, Section 924C made it a discrete offense to use or carry a firearm in connection with a predicate federal crime of violence or drug trafficking crime. A Section 924C violation triggers a mandatory minimum sentence of at least 5 years. Congress later added Section 924J to provide a different penalty scheme for Section 924C violations that cause death. Section 924J has no mandatory minimums. It instead authorized significant maximum sentences, including the death penalty or life in prison when the underlying violation is murder. Part B. The question in this case is whether subsection J also increased the number of convictions rather than just the maximum sentence that can result from a fatal violation of Section 924C1A1. The court resolves the question as a matter of statutory construction because whether punishments are unconstitutionally multiple cannot be resolved without determining what punishments the legislative branch has authorized. And the court undertakes this exercise in statutory construction with a thumb on the scale in the form of the Blockburger presumption, which instructs that Congress ordinarily does not intend to punish the same offense under two different statutes. It is undisputed that Section 924C1A1 and Section 924J define the same offense as per Blockburger, but the court has said that the Blockburger presumption can yield to a plainly expressed contrary intent. This case therefore turns on whether Congress plainly expressed an intent to overcome the Blockburger presumption by authorizing multiple convictions for one act that violates both Section 924C1A1 and Section 924J. To ascertain such intent, the court turns to statutory text, structure, and, for those who accept its help, legislative history. Part C. The text of Section 924 suggests strongly, perhaps conclusively, that Congress did not disavow Blockburger here. Congress included Blockburger surmounting language twice within subsection C itself. It mandated that a Section 924C1 conviction must be in addition to the punishment provided for the predicate, and it also mandated that a conviction under Section 924C5 for using or carrying armor-penetrating ammunition must be in addition to the punishment provided for the predicate or conviction under Section 924. The court has elsewhere called such in addition to language crystal clear evidence of a legislature's intent to overcome Blockburger, but Congress used no similar language with respect to the interplay between subsection C1 and subsection J. Section 1. The argument that subsection C's consecutive sentence mandate textually authorizes dual convictions misunderstands the inquiry. Blockburger addresses the permissibility of multiple convictions, not just multiple sentences, The assumption underlying the Blockburger rule is that Congress ordinarily does not intend to punish the same offense under two different statutes, where punishment means a criminal conviction and not simply the imposition of sentence. Accordingly, Section 924C's consecutive sentence mandate simply speaks past the question in this case, whether one act may result in two convictions. Before the consecutive sentence mandate gains any relevance, a court must first determine whether two punishments, convictions, may be imposed at all. Only if two convictions may coexist does a court consult the consecutive sentence mandate to arrange properly the resulting sentences. Section 2. The argument that subsection C1 and subsection J have different focuses and thus target different wrongs that may be punished cumulatively is equally unavailing. The conduct or result that differentiates a greater offense from its lesser included offense will often introduce some new focus, and that reality cannot do much to overcome the Blockburger presumption if the presumption is to retain its force. Part D. The statute's operation and structure provide no indication Congress expressed any will to overcome Blockburger. Laura answers any concern that defendants convicted of and sentenced under subsection J will be rewarded with more lenient sentences than those convicted of the less serious subsection C1 offense. There, the court explained that subsection J1 eschews mandatory penalties in favor of sentencing flexibility and reflects the seriousness of the offense using a different approach than subsection C1's mandatory minimum penalties, by authorizing the death penalty for murder and the same harsh punishment that the Federal Criminal Code prescribes for other manslaughters. If prosecutors fear that a subsection J sentence will dip below what subsection C1A1 would otherwise guarantee, they are free to choose between C1A1's low-end rigidity over subsection J's high-end flexibility. Neither the physical separation in the U.S. Code between subsection C1 and subsection J, nor the fact that subsection J's sentencing scheme operates without reference to subsection C's, overcomes the Blockburger presumption. If offenses share elements but have comprehensive, independently operating penalty schemes that suggests Congress intended to place in front of prosecutors a menu, not a buffet. Any analogy to Barrett versus United States, in which the court found Blockburger overcome even without express statutory language disclaiming the presumption, is inapt. Barrett involved a continuing criminal enterprise alleged to have spanned more than 5 years, and the continuing nature of the offense played a decisive role in the case. Barrett distinguished the facts there from what is involved here, the classic relation of the lesser included offense to the greater offense, wherein the very same conduct violates two statutes. Justice Jackson delivered the opinion of the court with respect to parts 1, 2, 3, 4A, and 4B, and an opinion with respect to part 4C, in which Chief Justice Roberts and Justices Sotomayor and Kagan joined. This case concerns the relationship between two provisions of 18 U.S.C. Section 924. The first, Section 924C1A1, criminalizes using, carrying, or possessing a firearm in connection with a federal crime of violence or drug trafficking crime. The second, Section 924J, prescribes different penalties, including, in certain circumstances, capital punishment, when a violation of subsection C causes death. Every defendant subject to subsection J has also necessarily violated subsection C. We consider here whether a defendant who commits a single act that violates both Section 924C1A1 and Section 924J may be convicted only under one provision or the other, or instead may suffer two convictions. All agree on the first step of the analysis. Subsection C1A1 and subsection J define the same offense under the test set forth in Blockburger v. United States. That consensus carries us most of the way to resolving this case, as we have long presumed that Congress intends to authorize only one conviction per offense. We resolve the rest by concluding that this presumption holds true here. Congress intended subsection J as an alternative, not a supplement, to subsection C1A1. At the very least, Congress did not clearly manifest a contrary intention, as it would have to do if it wished to authorize two convictions in these circumstances. We thus reverse in part the Second Circuit's contrary judgment. Part 1. Dwayne Barrett committed a series of robberies between August 2011 and January 2012. During one, Barrett's confederate shot and killed Gamar Dafala. Of the 7 charges on which Barrett was convicted, 3 are relevant here. Count 5 charged Barrett with Hobbs Act robbery of Dafala under 18 U.S.C. Section 1951. That count served as the predicate for 2 more. Count 6 charged Barrett with using a firearm during the commission of a crime of violence in violation of Section 924 C1A1, and Count 7 charged him with thereby causing death in violation of Section 924 J1. Footnote 1. Count 6 of the indictment technically charged Barrett with violating 18 U.S.C. Section 924 C1A3, which applies when the firearm is discharged rather than simply used, carried, or possessed. But the jury was charged with finding only that Barrett possessed or used the firearm, a violation of Section 924 C1A1, not 3. And the district court sentenced him in line with Section 924 C1A1. Before us, all agree that Barrett's Count 6 conviction was for a violation of Section 924 C1A1. Carrying on. Footnote 2. In his petition for a writ of certiorari, Barrett sought review of whether Hobbs Act robbery qualifies as a crime of violence such that it can serve as a predicate for a Section 924 C1 conviction. We did not grant certiorari on that question and do not pass on it here. Carrying on. A jury found Barrett guilty on all 7 counts, and the district court sentenced Barrett to a total term of 90 years of imprisonment. Barrett has since been aided by 2 of our decisions. After we decided United States v. Davis and vacated the Second Circuit's disposition of Barrett's direct appeal in light of that decision, the Second Circuit vacated one of Barrett's Section 924C convictions not at issue here. The district court then resentenced Barrett to 50 years in prison. 20 of those years came from concurrent sentences on 3 Hobbs Act robbery counts, including, as relevant here, Count 5. 25 years came from a consecutive term on Count 7, the subsection J conviction, into which the district court merged Count 6, the subsection C conviction. Footnote 3. The remaining 5 years, not relevant here, came from a consecutive mandatory minimum sentence on a different Section 924C count. Carrying on. Then we decided Laura v. United States, which, like this case, addressed the relationship between subsections C and J. Laura held that subsection J does not incorporate subsection C's consecutive sentence mandate. That mandate requires a subsection C sentence to run consecutively to any other term of imprisonment imposed on the person. It does not, we held in Laura, require the same of a subsection J sentence. When the district court sentenced Barrett in this case, it had been under the opposite impression. So Barrett appealed again and, bound by Laura, the Second Circuit vacated Barrett's sentence and remanded for another resentencing. In doing so, the Court of Appeals also passed upon the question that now comes before us. The district court, recall, had declined to sentence Barrett separately on counts 6 under subsection C and 7 under subsection J, both of which had as their predicate the same fatal Dafala robbery charged in count 5. The Court of Appeals rejected Barrett's argument that the double jeopardy clause required the district court to stay that course when the case returned for resentencing. The Court of Appeals did acknowledge that the government regularly concedes that subsection C1 and subsection J overlap and may not be punished cumulatively, a proposition with which the other circuits regularly agree. And it recognized that the 2 provisions qualify as the same offense under the governing test laid out in Blockburger, but it believed that, as construed in Laura, the 2 provisions are separate offenses for which Congress has clearly authorized cumulative punishments. Textually, the court pointed to Section 924 C1D2's mandate that a subsection C sentence must run consecutively to any other sentence, including, the court reasoned, to one under subsection J. Practically, the court highlighted that a contrary ruling would permit defendants who commit especially serious subsection C offenses ones resulting in death, to escape subsection C's mandatory minimums despite Congress's intent for every defendant convicted under that statute to be incarcerated for no less than the stated minimum term. And, turning to precedent, the court perceived our statement in Laura that subsection J evinced a different approach to punishment than subsection C to establish that the two provisions define different offenses, raising no double jeopardy concerns. The Court of Appeals therefore instructed the District Court to impose separate convictions and sentences on counts 6 and 7. Because the Second Circuit's decision deepened a split among the Courts of Appeals, we granted certiorari. Footnote 4. The Second Circuit's decision aligned with United States v. Julian. It diverged from most appellate courts that have considered the question. Carrying on. And because the government agrees with Barrett, we appointed an amicus curiae to defend the Second Circuit's judgment. Footnote 5. We appointed Charles L. McLeod to brief and argue the case in support of the judgment below. Mr. McLeod has ably discharged his responsibilities. Carrying on. We now reverse the Second Circuit's judgment in relevant part. Part 2, Section A. When Congress passed 18 U.S.C. Section 924C in 1968, the new subsection made it a discrete offense to use or carry a firearm in connection with a federal crime of violence or drug trafficking crime known as predicates. Footnote 6. In response to our decision in Bailey v. United States, Congress later added possession to the list of subsection C's prescriptions alongside use and carry. Carrying on. The original statute left open two questions relevant to today's case. It did not specify whether a subsection C conviction could coexist with or instead must displace a conviction for the underlying predicate. And assuming two convictions could coexist, it did not specify whether the two resulting sentences should run concurrently or consecutively. Congress answered both questions in 1971. On the first, Congress made clear that a subsection C conviction must be in addition to the punishment provided for the commission of the predicate. That is, a violation of subsection C ought to result in two convictions, one for subsection C and one for the predicate. On the second, Congress mandated that the two resulting sentences run consecutively, not concurrently. The term of imprisonment imposed under this subsection shall not run concurrently with any term of imprisonment imposed for the predicate. Congress later extended this second feature, the consecutive sentence mandate, beyond the relationship between subsection C's sentence and the predicate's sentence, so that the consecutive sentence mandate applies as between a subsection C sentence and any other term of imprisonment. Congress did not, however, expand the double conviction mandate. That mandate still instructs that only a subsection C1 conviction shall be in addition to the punishment provided for the underlying crime of violence or drug trafficking crime, that is, the predicate. Subsection C can be violated in several ways, but all trigger mandatory minimum sentences. Subsection C1A1 imposes a mandatory minimum sentence of 5 years. Other provisions within subsection C1 impose mandatory minimums up to life in prison, depending on the use and type of weapon and the defendant's recidivist history. Footnote 7. This too has changed over the years. Subsection C originally employed mandatory sentences exactly 5 years, exactly 10, and so on. The statute traded its mandatory sentences for mandatory minimums with no maximums in 1998. Carrying on. So if the predicate offense carries a mandatory minimum sentence of its own, then a defendant will face 2 consecutive mandatory minimum sentences for the single use of a single firearm. This case asks whether a different subsection of Section 924, subsection J, piles yet another layer of punishment atop, resulting in 3 stacked convictions and sentences, or instead it provides an alternative to subsection C1A1. Section B. Subsection J arrived decades after subsection C. Congress added it in 1994 in a provision entitled Death Penalty for Gun Murders During Federal Crimes of Violence and Drug Trafficking Crimes. The new subsection supplied a different penalty scheme for subsection C violations that cause death. Unlike subsection C, subsection J did not impose mandatory minimums. Instead, it authorized significant maximum sentences, including, true to the new provision's name, the death penalty if the underlying violation is a murder. Quote, a person who, in the course of a violation of subsection C, causes the death of a person through the use of a firearm shall, 1. If the killing is a murder, as defined in section 1111, be punished by death or by imprisonment for any term of years or for life, and 2. If the killing is manslaughter, as defined in section 1112, be punished as provided in that section. End quote. The references to section 1111 and section 1112 relate to the pre-existing murder and manslaughter statutes, respectively. Section 1111 sets a maximum penalty of death or life imprisonment for murder, and section 1112 sets a maximum penalty of 15 years for voluntary manslaughter and 8 years for involuntary manslaughter. Subsection J gave federal prosecutors tools they lacked in both the pre-existing subsection C and in the pre-existing murder and manslaughter statutes. Subsection C does not authorize the death penalty, for example. Subsection J thus raised the ceiling of punishments Section 924 authorized, and in doing so offered prosecutors flexibility of another sort, time. Section 1111, the General Federal Murder Statute, did already authorize the death penalty, but its jurisdictional reach, as well as that of the Manslaughter Statute, Section 1112, is limited to the special maritime and territorial jurisdiction of the United States. Footnote 8. The special maritime and territorial jurisdiction of the United States covers, among other things, lands reserved or acquired for the use of the United States and under the exclusive or concurrent jurisdiction thereof. It also pertains to locations like certain islands, rocks, or keys containing deposits of guano, and spaceships while in flight. Carrying on. The new subsection J had no such geographical limitation. It borrowed instead subsection C's broader jurisdictional hook, so subsection J expanded federal jurisdiction over more killings and authorized the death penalty for those amounting to murder. Part 3. This case asks whether subsection J also increased the number of convictions rather than simply the maximum sentence that can result from a fatal violation of section 924C1A1. Barrett says it did not, and for support he turns to the Fifth Amendment's Double Jeopardy Clause. But while his argument arrives in constitutional garb, it cannot be separated entirely from a resolution of the question of statutory construction. That is because the question whether punishments are unconstitutionally multiple cannot be resolved without determining what punishments the legislative branch has authorized. It is that question of congressional authorization that we answer today. Footnote 9. Because we conclude that Congress did not authorize 2 convictions in this context, we need not revisit whether Congress could do so consistent with the Double Jeopardy Clause. Carrying on. We undertake this exercise in statutory interpretation with a thumb on the scale in the form of the Blockburger presumption. Named for Blockburger v. United States, the presumption instructs that Congress ordinarily does not intend to punish the same offense under 2 different statutes. The first step in the inquiry, then, is to determine whether Section 924C1A1 and Section 924J define the same offense. To make that determination, Blockburger requires us to compare the provisions in question and ask whether each requires proof of a fact which the other does not. If the answer is yes, then the offenses prescribed by each statute are different, and the inquiry generally ends. If the answer is no, then the statutes define the same offense and the Blockburger presumption is triggered. But because we have treated Blockburger as a rule of statutory construction to help determine legislative intent, we have said that its presumption can yield to a plainly expressed intent to abandon it. Accordingly, the second step of today's analysis requires us to search for a clear manifestation of Congress's intent to authorize more than one punishment. All involved in this case share common ground as to the first step of the analysis. The Court of Appeals, Barrett, the government, and court-appointed amicus agree that Section 924C1A1 and Section 924J define the same offense. Footnote 10. We express no view as to whether the same is true as to other versions of the Section 924C offense, as Barrett was convicted under Section 924C1A1. Put differently, while we recognize that Section 924C can be violated in a number of ways, this case involves only the base offense found at Section 924C1A1. Our holding therefore applies only to that clause. Carrying on. After all, the relationship between subsection C1A1 and subsection J is the classic relation of the lesser included offense to the greater offense, wherein the very same conduct violates two statutes, one which is fully subsumed within the other. And all lesser included offenses are the same as their greater cousins under Blockburger. This case therefore turns on the analysis's second step, determining whether Congress clearly intended to authorize multiple convictions for one act that violates both Section 924C1A1 and Section 924J. To ascertain such intent, we turn to statutory text, structure, and, for those who accept its help, legislative history. Only if those tools leave us certain that Congress intended to break from its normal practice and authorize multiple convictions for the same offense will we shed the presumption. Part 4, Section A. We begin with the text. Textual clues are critical because Congress is aware of the Blockburger rule and legislates with it in mind. So Congress typically includes Blockburger surmounting language when it wishes to authorize dual convictions for the same offense. Subsection 1. The text of Section 924 suggests strongly, or perhaps conclusively, that Congress did not disavow Blockburger here. Not for lack of know-how, Congress twice wrote Blockburger surmounting language into subsection C itself. Congress mandated that a Section 924C1 conviction must be in addition to the punishment provided for the predicate, and it also mandated that a Section 924C5 conviction for using or carrying armor-penetrating ammunition must be in addition to the punishment provided for the predicate or conviction under Section 924. We have elsewhere called such in addition to language crystal clear evidence of a legislature's intent to overcome Blockburger. Footnote 11. Significant, too, is the fact that Congress added the in addition to language to Section 924C1 in 1971 and passed Section 924C5 in 2005. Congress thus demonstrated its ability to overcome Blockburger in subsection C both before and after it passed subsection J in 1994. Carrying on. In short, when Congress has the will to authorize dual convictions for the same offense, Congress has no difficulty in expressing it. But Congress used no similar language with respect to the interplay between subsection C1 and subsection J. Its silence on the topic speaks volumes. Subsection 2. Like the Court of Appeals, amicus challenges the premise of this assessment. He insists that Congress has textually authorized dual convictions under subsection C1 and subsection J. For proof, he points to subsection C's consecutive sentence mandate. It reads, quote, "Notwithstanding any other provision of law, no term of imprisonment imposed on a person under this subsection shall run concurrently with any other term of imprisonment imposed on the person, including any term of imprisonment imposed for the crime of violence or drug trafficking crime during which the firearm was used, carried, or possessed." End quote. As amicus would have it, this instruction permits, actually requires, a subsection C1 conviction to add on to any other conviction, including one under subsection J. This deployment of the consecutive sentence mandate misunderstands today's inquiry. The argument attempts to make Blockburger purely about sentences, so that an instruction to run sentences consecutively rather than concurrently makes clear Congress's intent to overcome the presumption. But Blockburger addresses the permissibility of multiple convictions, not just multiple sentences. The assumption underlying the Blockburger rule is that Congress ordinarily does not intend to punish the same offense under two different statutes, where punishment means a criminal conviction and not simply the imposition of a sentence. It is for this reason that running sentences concurrently does not avoid the problem. An unauthorized second conviction, even if it results in no greater sentence, is an impermissible punishment. Accordingly, Section 924C's consecutive sentence mandate simply speaks past the question in this case, whether one act may result in two convictions. To that question, it is no answer to say, as the consecutive sentence mandate does, that a term of imprisonment imposed for a conviction shall run consecutively to any other term of imprisonment imposed. Before the consecutive sentence mandate gains any relevance, a court must first determine whether two punishments, convictions, may be imposed at all. Only if two convictions may coexist does a court consult the consecutive sentence mandate to arrange properly the resulting sentences. This description is not merely the law as it exists, it is the law as Congress understands it. When Congress amended subsection C in 1971, it added two distinct instructions as recited above. The first, that a subsection C1 conviction must be in addition to the punishment provided for the predicate, answers the threshold question: may one act spawn two convictions, one for subsection C1 and one for the predicate? The second, the consecutive sentence mandate, answers the follow-on question: presuming the existence of two convictions, should their resulting sentences run concurrently or consecutively? Amicus would have the second instruction answer the first question. But Congress has already addressed it. A subsection C1 conviction adds to the predicate conviction. Nowhere does the statute prescribe the same in relation to a subsection J conviction. Footnote 12. Section 924C is not unique in this way. Congress frequently gives these two distinct instructions, understanding that one speaks to the dual conviction question and the other to the sentence arrangement issue. Carrying on. Subsection 3. Amicus's second textual argument is equally unavailing. Turning away from the concrete and toward the abstract, Amicus tells us that subsection C1 and subsection J have different focuses. Subsection C1, he points out, calibrates its punishment to the use of the firearm, the type of firearm, and recidivism. By contrast, subsection J focuses on something irrelevant to subsection C1, the harm, namely death, inflicted. From this, Amicus urges us to conclude that the two subsections target different wrongs and thus may be punished consecutively, and thus may be punished cumulatively. In our search for congressional intent, we might in some circumstances think that when two provisions focus on entirely different interests, that suggests Congress intended them to accumulate rather than swap out. Whatever those circumstances, this is not one. Amicus stretches to find a common thread running throughout subsection C1. He bundles firearm use, firearm type, and recidivism, and places them in opposition to harm. But it is not obvious that those three features form a theme of any significance such that they can create the contrast Amicus wants to glean from them. In any event, the conduct or result that differentiates a greater offense from its lesser included offense will often introduce some new focus. That reality cannot do much to overcome the Blockburger presumption if the presumption is to retain its force. In sum, if Congress expressed any will to overcome Blockburger in this scenario, it must be found somewhere other than the statutory text. Section B. Failing textual support, Amicus turns to the statute's operation and structure, but this ground proves only slightly more fertile. Primarily, Amicus fears that defendants convicted of and sentenced under subsection J will be rewarded with more lenient sentences than those convicted of the less serious subsection C1 offense. He points out that subsection C1 imposes mandatory minimums while subsection J speaks in terms of maximums. He insists that, rather than let subsection J offenders out from under subsection C1's mandatory minimums, Congress must have intended to authorize subsection C1's mandatory minimums plus any punishment doled out under subsection J. Laura answers this question without breaking a sweat. There we explained that subsection J, along with several other provisions enacted simultaneously, eschews mandatory penalties in favor of sentencing flexibility. It was not lost on us in Laura, nor is it now, that subsection J defines an especially serious offense. Subsection J simply reflects that seriousness using a different approach than subsection C's mandatory penalties, by authorizing the death penalty for murder and the same harsh punishment that the Federal Criminal Code prescribes for other manslaughters. It is for that reason, among others, that Laura, anticipating the question this case presents, explained that our conclusion in that case aligns with the mutually exclusive relationship between subsection C1A1 and subsection J that we endorse today. Just as subsection J's seriousness is not lost on us, we are confident, as Congress apparently was, that it will not be lost on sentencing judges. Bound by 18 U.S.C. section 3553A to craft a sentence that, among other considerations, reflects the seriousness of the offense and avoids unwarranted sentence disparities among similarly situated defendants, sentencing judges will doubtless recognize the relevance of a victim's death when sentencing under subsection J. Amicus's worry thus strikes us as more theoretical than realistic, but if it threatens to manifest, it is not without remedy. If, in a given case, prosecutors fear that a subsection J sentence will dip below what subsection C1A1 would otherwise guarantee, they are free to choose subsection C1A1's low-end rigidity over subsection J's high-end flexibility. Footnote 13. Amicus molds this same basic argument into many forms, sketching situations in which the maximum sentence under subsection J could, at times, dip below the minimum sentence under subsection C1, though not under subsection C1A1. But the most this line of attack shows is that Congress could rationally have designed subsection J to supplement rather than provide an alternative to subsection C1. It does not come close to showing that Congress actually intended to do so, much less that it has clearly indicated such intent. Carrying on. There is a textual answer to this concern too, and here again section 924C5 plays the foil. That provision, which pertains to the use of armor-piercing ammunition, states that in addition to the punishment provided for the predicate or conviction under this section, a defendant shall face a mandatory minimum sentence of 15 years and, if death results, shall be sentenced in accordance with a scheme that mirrors subsection J's. This illustrates that when Congress wished to preserve a mandatory minimum it feared might otherwise disappear, it so specified, but subsection J, we explained in Laura, is cast from a different mold. Next, Amicus highlights the physical separation in the U.S. Code between subsections C1 and J, and he underscores their independent operation, emphasizing that subsection J's sentencing scheme operates without reference to subsection C's. We have not bought such arguments before. Consider, for instance, the statutes at issue in Ball, statutes whose elements overlapped but whose sentencing schemes diverged. Those provisions, which were then located at 18 U.S.C. sections 922H and 1202A, prohibited certain categories of people from, respectively, receiving and possessing certain firearms. The provisions occupied parts of the code much farther apart than the subsections of section 924 at issue here, and in United States v. Batchelder, we explained that each statute, in conjunction with its own sentencing provision, operated independently of the other such that the statutes were each fully enforceable on their own terms. We therefore concluded that the provisions did not incorporate each other's penalties. Yet, 6 years later, in Ball, we concluded that the two independent provisions were also mutually exclusive under Blockburger. What Blockburger is to Ball, Laura is to this case. Subsection J shares subsection C's elements but not its sentencing scheme. Instead, subsection J supplies its own comprehensive set of penalties that apply instead of subsection C's, and as in Ball, this dynamic magnifies rather than eliminates the likelihood that the Blockburger presumption holds true. After all, if offenses that share elements, as they must to satisfy Blockburger, have penalties that operate on their own rather than by reference to each other, that suggests that Congress intended to place in front of prosecutors a menu, not a buffet. Finally, Amicus analogizes this case to Barrett, in which we found Blockburger overcome even without express statutory language disclaiming the presumption. Barrett examined the relationship between the continuing criminal enterprise statute and its constituent offenses. The distinctions from Barrett are legion, because the justifications we offered for that decision are legion. But most straightforwardly, Barrett distinguished the classic relation of the lesser included offense to the greater offense, wherein the very same conduct violates two statutes. In Garrett, by contrast, the continuing criminal enterprise was alleged to have spanned more than 5 years. The court did not believe that Congress wished to require the government to choose between prosecuting the defendant for early predicates and forfeiting a later CCE charge on the one hand, and allowing him to go on breaking the law to preserve the possibility of a CCE charge on the other. The continuing nature of the offense played a decisive role in the case. One who insists that the music stop and the piper be paid at a particular point, we reasoned, must have at least stopped dancing himself before he may seek such an accounting. Footnote 14. We have also explained that Garrett merely adhered to our understanding that legislatures have traditionally perceived a qualitative difference between conspiracy-like crimes and the substantive offenses upon which they are predicated. The case before us now does not implicate that dynamic. Carrying on. Today's circumstances are markedly different. Here we have nothing more than the classic relation of the lesser included offense to the greater offense. Section C. Amicus turns finally to legislative history. We have said that legislative history may fortify a conclusion that Congress intends to overcome Blockburger. But the legislative history amicus offers pertains to double convicting for subsection C and its predicates, a practice Congress expressly authorized in the text. For obvious reasons, this is unhelpful data for interpreting the relationship between subsections C and J. If anything, it illuminates the sort of discussion that characterizes congressional deliberation over legislation that does intend to authorize cumulative punishment, and thus highlights the notable absence of any similar deliberation over subsection J. Rather, the only legislative history that is relevant to today's inquiry accords with Barrett's understanding of subsection J. That legislative history suggests that, rather than stacking punishment or creating a brand new offense, subsection J, at the time styled subsection I, made a capital offense out of a pre-existing crime, the one at subsection C. Like its silence in the statutory text, Congress's debate floor silence says a lot. The Blockburger presumption is long settled, muscular, and fundamental to our law. We think it highly unlikely that the lawyer's body that is Congress discarded Blockburger without comment here. Congress has not authorized convictions under both 18 U.S.C. sections 924 C1A1 and J for an act that violates both provisions. The part of the judgment of the Court of Appeals that held otherwise is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Gorsuch concurring in part. On the morning of December 12, 2011, Dwayne Barrett participated in an armed robbery that left a man dead. For this, Mr. Barrett was convicted twice in federal court. Once for using a firearm during a crime of violence under 18 U.S.C. section 924 C1A, and once for causing a death during a section 924 C violation in violation of section 924 J. For his two convictions, the Second Circuit ordered two separate punishments, a prison term for his section 924 C1A violation, plus another consecutive prison term for his section 924 J violation. All of which raises the question, if Mr. Barrett is convicted and punished for both crimes, has he been twice put in jeopardy for the same offense in violation of the Double Jeopardy Clause? There is no doubt how we would answer that question if the government had prosecuted Mr. Barrett under section 924 C1A and section 924 J in two successive proceedings. The analysis would begin and end with Blockburger v. United States. Under Blockburger, two provisions create the same offense for double jeopardy purposes unless each provision has an element the other lacks. Here, all agree that section 924 C1A has no element that section 924 J lacks. So the two provisions create the same offense, and the double jeopardy clause would bar the second prosecution. What happens, though, where, as here, the government brings two charges for the same offense concurrently in the same proceeding rather than successively in two separate ones? That question does not appear to have arisen much in our nation's early years. Maybe it didn't in part because criminal codes were considerably thinner then, affording prosecutors fewer opportunities to bring overlapping charges. Maybe it didn't in part, too, because of the traditional maxim that an indictment should not include more than one felony, which left multiple count indictments vulnerable to being quashed by trial judges. But if the question didn't arise much in the past, it is of obvious relevance in our times. These days, federal and state criminal codes have exploded with scores of repetitive offenses on the books. Today's prosecutors bring as many overlapping felony charges as they can in a single case to see what will stick, and courts often tolerate the practice. The litigants before us proceed on the unexamined premise that Blockburger works differently in concurrent prosecutions than it does in successive ones. In concurrent prosecutions, they assume Blockburger creates a mere presumption for ascertaining congressional intent. Because Section 924C1A and Section 924J create the same offense under Blockburger, they say we should presume that just one of Mr. Barrett's convictions can stand unless Congress has clearly directed otherwise. The only question that divides the litigants is whether, in fact, Congress included clear directions in Section 924 authorizing both convictions. Addressing the case as the litigants have framed it, the court today holds that nothing in Section 924 overcomes the Blockburger presumption, so only one of Mr. Barrett's convictions can stand. I agree with that as far as it goes, but it's also hard not to wonder where the litigants' presumptive version of Blockburger comes from. If the Constitution always prohibits the government from securing two convictions for the same offense in successive prosecutions, why would it sometimes tolerate a different result in concurrent prosecutions? One thing here is certain: the litigants framed this case the way they did because our cases speak confusingly about the role of the double jeopardy clause in concurrent prosecutions. This court has sometimes said that the clause protects against multiple punishments for the same offense. And we have held that multiple convictions for the same offense, even when secured in a single proceeding, count as multiple punishments. From this, it would seem to follow that Congress cannot authorize multiple convictions for the same offense in concurrent prosecutions. But this court has also sometimes said that in the concurrent prosecution context, the clause merely directs courts to ascertain statutory meaning accurately. The question of what punishments are constitutionally permissible, we once wrote, is no different from the question of what punishments the legislative branch intended to be imposed. Someday we will need to resolve the tension in our case law, and when we do, I see two likely solutions. One would be to say out loud what some of our cases imply, that the constitutional phrase, the same offense, means different things in different contexts. In the successive prosecution context, two charges amount to the same offense if they fail the Blockburger test. But in the concurrent prosecution context, two charges amount to the same offense only if they fail the Blockburger test and Congress has not clearly intended punishment under both. That solution, though, would be a curious one indeed. Not only would it allow Congress to permit in the concurrent prosecution context what we have long held the Constitution forbids in the successive prosecution context, really it is a little embarrassing to assert that the single term, the same offense, in the double jeopardy clause has two different meanings. A second solution would be to recognize, as others of our cases imply, that two charges amount to the same offense under the double jeopardy clause if they fail the Blockburger test, full stop. So a defendant cannot be prosecuted for both charges in successive proceedings, nor may he be convicted twice, much less sentenced twice, for both charges just because they happen to be brought concurrently. True, this approach would require us to admit that Blockburger is not, after all, a mere presumption in the concurrent prosecution context. But saying that much would give the constitutional phrase the same offense a consistent meaning and treat like cases alike. Nor would taking that step represent some giant leap. Our cases discussing Blockburger as a mere presumption in the concurrent prosecution context were decided during a relatively brief period when this court didn't take Blockburger very seriously in any context, even when it came to successive prosecutions. Since then, however, we have expressly renounced that approach, reaffirming that Blockburger's long-settled rule controls what counts as an offense for double jeopardy purposes in successive prosecutions. Tellingly, too, in all the years since Dixon, we have not found a single case in which the Blockburger presumption against concurrent prosecutions for the same offense was, in fact, overcome by a clear congressional command. In short, the analytical foundations of the presumptive version of Blockburger have been gravely undermined by subsequent developments. Perhaps some might worry about the consequences of this second solution. Today, after all, prosecutors routinely bring concurrent charges for greater offenses and their lesser included variants, giving juries several degrees of culpability to choose from. One might wonder whether affording the double jeopardy clause the same meaning in the concurrent prosecution context that it already enjoys in the successive prosecution context would render this practice illegal. It would not. A jury could reach a guilty verdict on two charges that constitute the same offense, but no double jeopardy problem would arise so long as the court does not enter judgments of conviction on both. It may not be clear at a trial's outset which charge, if any, will yield a conviction, but it will be certain all along that, when judgment day comes, the defendant will be convicted and punished only once for any given offense. Today, to be sure, the court has no occasion to tangle with any of this. The parties have not asked us to address the tension in our case law. Nor does anything here turn on its resolution, given the court's holding that one of Mr. Barrett's convictions must go even under the merely presumptive version of Blockburger. All this the court rightly takes care to acknowledge. On that understanding, I join all but part 4C of Justice Jackson's opinion, but while today's decision is correct as far as it goes, sooner or later we will have to clear up the confusion, and to my eyes this case serves as a poster child for how that confusion should be resolved. Mr. Barrett really was charged twice for one offense. He really was convicted twice. Before our intervention, he really was set to be criminally punished twice. And whatever Congress might or might not intend, that is double jeopardy. And that is it for the opinions in this case. At the outset, I am not particularly familiar with the statutory scheme at issue in this case, but at least from the court's telling of it, the court's decision seems to make sense to me. The court says there's this presumption coming from, this case, Blockburger, that Congress doesn't speak clearly, it doesn't intend to punish somebody twice for the same offense. Indisputably, nobody even contends otherwise. The two statutes at issue here, or the statutory provisions at issue here, do concern the same offense, and there's no clear indication, so you can't punish Barrett twice for the same offense here. And I mean, the case was decided unanimously, except as to part, 4C. So, yeah, I don't have all that much to say against the court's opinion here. It seems to make sense. I did think it was interesting that a majority of the court, I believe it was 5 justices, did not sign on to part 4C, presumably because those 5 justices do not like looking at legislative history, and Part 4C was all about legislative history. Kind of surprises me to see Justice Roberts signing on to that part, but I guess he is, among the conservative justices, probably the more likely to side with the, liberal justices, so I guess it's not terribly surprising. I don't know. It just seemed to me that the conservative side of the bench had pretty decisively said over and over and over again, we're not looking at legislative history. It's not informative as to the meaning of statutory text. Stop bringing it up. And Justice Jackson does seem, especially in oral arguments, I've noticed this tendency over and over and over again to want desperately to look at legislative history, which, to be honest, does bug me a little bit. But yeah, so that was kind of interesting. One thing that also sort of jumped out at me was in one of the footnotes, Justice Jackson points out that Mr. Barrett is of the position and asks the court to decide in his favor that Hobbs Act robbery does not qualify as a crime of violence for purposes of Section 924. And that struck me because I remember reading in a previous case, or I thought I remembered reading in a previous case, that had already been decided. I misremembered, but it was in, I believe, United States versus Taylor, that attempted Hobbs Act robbery or the court had decided that attempted Hobbs Act robbery did not qualify as a crime of violence for the purposes of that statute. So that kind of jumped out at me. I was like, wait, I thought the court already decided this. No, not quite. They were talking about attempted object robbery in that case, but yeah, honestly, I think the most interesting part of this case was probably Justice Gorsuch's lone partial concurrence. Once again, I like Justice Gorsuch. I tend to like Justice Gorsuch. And yeah, he addresses something that was kind of nagging me throughout the opinion, which is the double jeopardy clause of the Fifth Amendment. It says you can't twice be put in jeopardy for the same offense. And the court is kind of, all parties really in this case seem to be operating on the presumption that if somebody is prosecuted for two crimes concerning the same act, the same offense, and is convicted on both concurrently, that's fine. And that kind of nagged me the entire time. I'm like, that doesn't seem to make sense. Like that seems to run face first to the double jeopardy clause. And of course, that's not an issue that the court needs to address in this case, as Justice Gorsuch points out, and as the court points out as well. You know, we don't need to address that in this case. But I did like that Justice Gorsuch went ahead and did so anyway, because again, it was kind of nagging at me the whole time. I'm like, that doesn't seem to make a whole lot of sense that somebody can be convicted for two crimes for the same offense, and that's constitutional under the Fifth Amendment somehow, so long as Congress has clearly indicated that that was his intent. I'm like, I don't think Congress can ever overcome the Constitution, no matter how clear its intent. In fact, if its intent is clearly to overcome the Constitution, that's an even greater indictment against the law at issue, I would think. But yeah, Justice Gorsuch addresses this and he says, yeah, the straightforward answer seems to be the language, the same offense, means the same thing whether a person is being prosecuted successively or prosecuted concurrently. And in a successive prosecution, this obviously wouldn't fly. Like, not at all. You couldn't prosecute somebody under one statutory provision for an offense and then come back again and prosecute them again under a different statutory provision for the same offense. That runs face first into the double jeopardy clause, and it doesn't make a whole lot of sense to say, well, the same offense means different things depending on how the prosecution is structured. Like, oh, as long as they bring the charges concurrently, it's fine, but if it's excessive, it's not fine. Yeah, that didn't sit right with me, and that doesn't sit right with Justice Gorsuch, and I think rightly so. Yeah, and then he points out, like, yeah, this isn't really breaking new ground. This isn't going to be super disruptive. Like, if we ever have to address this issue, and we go with that course, saying, yeah, the same offense means the same offense. It doesn't matter how a person is prosecuted successively, concurrently. Two convictions for the same offense can't stand. You know, he says this isn't going to be super disruptive because, like, yeah, we've got this very common practice nowadays of bringing a bunch of overlapping charges and lesser included offenses and all this to try and see what sticks, and juries often convict on multiple. That's fine. That's still constitutional as long as the court doesn't render multiple convictions. And I mean, that's, I guess, comforting somewhat that, you know, this sort of solution is not going to be particularly disruptive. That said, I don't really care all that much if it's going to be disruptive or not. Like, if prosecutors have developed a practice in recent years that violates the Constitution, then it violates the Constitution. And I don't care if it's going to make their job harder to hold them to the Constitution. That's actually kind of the point. But I don't know, for people more concerned about the practical issues, that's something nice to throw in there, I guess. But I think that's about all I have to say about the case. So, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts. If you like to support the podcast, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members have access to episodes early and to any bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we will continue through the recently released 2025 term opinions. Until then.